Pennsylvania's Right to Know Law, RTKL, Act 3 of 2008, was signed into law by Governor Edward Rendell on February 14, 2008, with the majority of the provisions having an effective date of January 1, 2009. Sections 101 and 102 of the RTKL, which set forth the name of the statute and various definitions, took effect immediately, along with Section 1310, which created the Office of Open Records, OOR, within the Pennsylvania Department of Community and Economic Development. Chapters 15 and 17 of the RTKL took effect on July 1, 2008. Chapter 15 requires the Pennsylvania State University, the University of Pittsburgh, Temple University, and Lincoln University to disclose their respective IRS Form 990s, Return of Organization Exempt from Income Tax, the salary of their officers and directors, and the salaries of the top 25 highest paid employees. These financial disclosure requirements were imposed as a reaction to appellate decisions where courts addressed whether the salaries of then Pennsylvania State University football coach Joe Paterno and Pennsylvania State University administrators were subject to public access. These universities, defined as state-related institutions, are not subject to the general disclosure requirements within the remainder of the RTKL, which has led to calls to revise the statute. Chapter 17 requires Commonwealth agencies, legislative agencies, and judicial agencies to submit contracts for at least $5,000 worth of goods or services to the Treasury Department. The Treasury Department is required to post these contracts or a summary of the contracts, with the permissible redaction of confidential proprietary information and other exempt material on its website and make paper copies of these contracts available for public access. The remainder of the RTKL delineates the practice and procedure of requesting records from government agencies. Unfortunately, many of the provisions do not provide much specificity and, on occasion, appear to contradict each other, resulting in a large amount of litigation and criticism from courts. As then Chief Justice Ronald Castile noted in a dissent in a Pennsylvania Supreme Court's decision that interpreted the proper standard and scope of review to be applied when reviewing decisions of the OR. I commend the court for undertaking the Herculean task of seeking to reconcile inconsistencies abounding in the Right to Know law. In my tenure on the court, it is difficult to recall a statute that has so quickly generated so much litigation, involving seemingly overlooked foundational matters. The plain language of the RTKL reveals little legislative attention paid to establishing a defined means of judicial review following administrative review. This lapse perhaps resulted from an expectation that the vast majority of disputes would be resolved at the agency level, as happens in other Commonwealth agency disputes, and would not put parties to the additional inconvenience, expense, and delay that judicial review, including direct review of fact-bound issues, as of right in this court, entails. While the expectation of streamlined agency review may have materialized to a degree, the deficiencies in the RTKL, combined with the OR's apparent inefficacy and inconsistency in performing its regulatory task, a point to which I have written in the past, have left parties with the worst of worlds, an incomplete or unsatisfactory administrative process that all too often forces unready and fact-bound merits disputes into the court system. As a result, the court system is faced with foundational questions regarding the appropriate standard and scope of judicial review, as well as waiver before a principled process of review may be conducted. In this confused situation, the majority adopts a construction of the statute, implicating de novo judicial review following the administrative process, a construction whose consequences the General Assembly could not have intended. Indeed, the ambitious timelines for disclosure in the RTKL suggest that the legislature did not contemplate the circumstances that have unfolded. Pure de novo review of all issues, by the Commonwealth Court in its original jurisdiction, for instance, inevitably adds delay and builds expense into the process of accessing public records. As this court explained in Mercury Trucking, Inc. versus Pennsylvania Public Utility Commission, de novo review in a court of the Commonwealth following administrative review diminishes the utility of administrative proceedings and pointlessly duplicates such proceedings, increasing the cost of litigation. Moreover, the de novo judicial review process implicates the structural loss of the OR's developing expertise in interpreting the RTKL, from which the deferential review standard generally derives. Delay and expense is compounded when untold numbers of appeals are subject to the new procedure. Thus, the de novo procedure described by the majority tasks the Commonwealth Court with holding evidentiary hearings in fact-bound routine matters involving record request disputes, forcing that court to step out of its traditional appellate role in administrative matters. I question whether the General Assembly intended to burden that already busy court with the duty to act as a trial court in matters that obviously should be resolved quickly and efficiently at the administrative level. Moreover, in cases involving requests of Commonwealth agencies, I question whether the General Assembly either contemplated or intended the consequence that this court would then be obliged to entertain appeals as of right in cases where the disputes overwhelmingly are factual. To the extent that the statute may be read as intending a de novo review process in the Commonwealth Court, with this court becoming the repository for appeals of right, implicating review for error in RTKL matters, the legislative scheme borders on the absurd and unreasonable. As with most other matters that commence at the administrative agency level, the proper role for the Supreme Court is to entertain appeals on its discretionary docket when there are special and important reasons implicated, such as resolution of conflicting precedent and consideration of legal questions of first impression or of substantial public importance. If the intent of the General Assembly was a measured decision to turn the Commonwealth Court into a trial court in these cases, and then to reposit direct appeals in RTKL matters in the Supreme Court, then this court will need to erect a screening mechanism to avoid the inevitable inundation of fact-bound appeals. What is plain beyond question is that the statute is in need of significant revision and refinement. Short of that, however, the OR is statutorily positioned to implement the existing legislation in a manner that would bring order out of this chaos and ensure a fairer and more timely review process. Remarkably, it appears that the OR still has not promulgated regulations to govern the administrative appeal process. Instead, the OR employs an appeals procedure described in its interim guidelines, which significantly departs from administrative procedures employed by most other Commonwealth agencies, and which apparently was intended to address due process concerns. These interim guidelines are not formal regulations promulgated in accordance with the process required by the Commonwealth Documents Law and the Commonwealth Attorneys Act, which require inter alia a period of public comment and review by the Attorney General for form and legality. As mere informal policy, the OOR's guidelines are also vulnerable to frequent and potentially disruptive ad hoc amendment. Unfortunately, the RTKL permits the OOR to operate indefinitely under these interim guidelines and outside of the traditional administrative review process. Concomitantly, the RTKL fails to articulate any fail-safe procedures to vindicate litigants' due process rights during the OOR administrative process. Again, the result is defaulting cases into the court system following what amounts to meaningless agency review. I favor legislative refinement to address these concerns. The courts are not in a position to make the necessary adjustments to the RTKL in the case-by-case method available to us, and our decision regarding discrete aspects of the appellate review process can act as nothing more than a blunt tool where a scalpel is more appropriate. Furthermore, the endeavor is pointless, given that the General Assembly can displace the judicial band-aids at any time by legislative action. To that end, if the General Assembly fails to make necessary adjustments, and the OOR continues in its failure to establish a regulatory process of administrative review that ensures adequate due process for litigants within the limitations of the flawed authorizing statute, including a process to resolve factual disputes, I would entertain the alternative that all decisions of the OOR should be reversed per curiam with a directive to provide such process, and then allow for meaningful appellate review of the agency decision in the proper court, with discretionary review for significant issues available in this court. The remainder of this book seeks to address the RTKL and how the OOR and courts have interpreted the statute and filled in perceived gaps in the legislative language. The Pennsylvania Supreme Court has noted that the intent of the RTKL is to provide rapid access to records. As this court has recognized, various provisions of the RTKL demonstrate an intent for an expedited determination of RTKL requests and for disputes to be resolved in an efficient and timely fashion. The law's predecessors, the Right to Know Acts of 1957 and 2002, set forth no time limit within which an agency was bound to respond to a request for disclosure, and appellate review was limited to determining whether an agency's denial was supported by just and proper cause. Requesters bore the burden of demonstrating that a record was a public record and that they were entitled to see it. The General Assembly passed the RTKL in 2008, overhauling that process. Agencies now bear the burden of proving an exception to the presumption that all records are public records. Read together, various sections of the RTKL provide that parties will see their requests resolved or be before an appellate court within less than 4 months of the initial filing of the request, absent an agreed-upon extension. Please note that this video is not intended to be legal advice and does not create an attorney-client relationship. Please contact Attorney Schnee at chadwickashneelegal.com or 717-400-5955 to learn more about the open records requirements under the Right to Know law.